As we continue to build upon the foundation established in earlier lessons on the Arizona Consumer Fraud Protection Act, CFPA, it becomes essential to explore one of the most frequent and serious violations that occur in real estate: misrepresentation of material facts. This concept lies at the very heart of the 1967 Consumer Fraud Protection Act, codified under ARS Section 44-152 1 through Section 44-1534, and it defines much of the conduct that the law seeks to prevent. In real estate, where trust and transparency are indispensable, even minor inaccuracies or omissions can mislead consumers and result in significant harm. The Act was designed to prevent such misconduct before it damages the public and to hold accountable any individual or entity who deceives through false statements or concealment. To understand misrepresentation under this law, we must first look to ARS Section 44-1522, which makes it unlawful for any person, in connection with the sale or advertisement of merchandise, including real estate, to use any deception, false promise, misrepresentation, or concealment of a material fact with the intent that others rely on such conduct. A material fact is any fact that a reasonable person would consider important when deciding whether to enter into a transaction. In real estate, material facts can include physical conditions of the property, legal status of ownership, zoning restrictions, environmental hazards, financing terms, and even surrounding neighborhood conditions that could affect value or desirability. For example, if a seller knows that a property has a leaking roof but tells a buyer it was recently repaired, that statement constitutes a misrepresentation of a material fact. Similarly, if a broker advertises that a property includes irrigation rights, when those rights do not exist, it is considered deceptive, even if the buyer never completes the purchase. The law does not require the buyer to suffer a financial loss, merely that the conduct was deceptive or had the potential to mislead. This distinction underscores that the CFPA is a preventive law, not just a remedial one. Misrepresentation can occur through both acts of commission and acts of omission. Acts of commission involve making false or exaggerated statements. Examples include overstating square footage, claiming a home is move-in ready when significant repairs are needed, or asserting that a property is zoned for commercial use. When it is not, acts of omission involve withholding or concealing information that should be disclosed, such as known pest infestations, flood risks, or unpermitted additions. Arizona courts have made it clear that omissions can be just as fraudulent as false statements. In Dunlap versus Jimmy GMC of Tucson, Inc., 1984, the court held that concealing a material fact that one is obligated to disclose is equivalent to a false representation under the law. In the context of real estate, ARS Section 32-2153 reinforces this principle by authorizing the Arizona Department of Real Estate, ADRE, to discipline licensees for making any substantial misrepresentation or false promises likely to influence, persuade, or induce. This statute aligns with the CFPA by ensuring that licensees remain truthful in all business dealings. Furthermore, Commissioner's Rule R4-28-1101 requires every licensee to deal fairly with all other parties to a transaction, meaning that even when acting as an advocate for a client, an agent must not deceive or mislead others. A practical illustration of misrepresentation can be seen in a scenario where a listing agent describes a home as having new plumbing, when in fact, only a few pipes were replaced several years ago. Although the statement may appear minor, it creates a false impression that could influence a buyer's decision, qualifying as a misrepresentation under ARS Section 44-1522. Another example might involve a property advertised as free of HOA fees, when in reality, the property is within a homeowners association that charges annual dues. Even if the fees are small, the omission of that fact is considered material, since it affects the ongoing financial obligation of ownership. The CFPA also extends to real estate advertising and digital marketing. Licensees must ensure that every public statement, image, or online listing is accurate under Commissioner's Rule R4-28-502. Advertising must not be false, misleading, or deceptive. For instance, altering photos to hide defects or using virtual staging to misrepresent the true condition of a property may constitute consumer fraud. Similarly, describing a lot as ready to build, when it lacks utility access, could violate both ARS Section 44-1522 and ARS Section 32-2153. One of the most important legal standards in determining misrepresentation is whether the omitted or false information would have been significant to the buyer's decision-making process. In Carruthers v. Underhill, 1975, the Arizona Supreme Court established that the duty to disclose material facts exists when one party has superior knowledge not readily available to the other, and when withholding that knowledge would mislead. This decision reinforces the responsibility of sellers and agents to disclose all facts that could materially impact the value or desirability of a property. The consequences of misrepresentation are serious. Under the CFPA, the Arizona Attorney General can pursue civil actions, seeking injunctions, restitution for victims, and civil penalties under ARS Section 44-1528. The ADRE may also impose administrative sanctions, including license suspension or revocation under ARS Section 32-2153. Courts have repeatedly emphasized that intent to deceive is not necessary to establish a violation. Negligence or recklessness in providing false information is sufficient to trigger liability. Review summary. Misrepresentation under the Arizona Consumer Fraud Protection Act occurs when a person makes a false statement or conceals a material fact in connection with the sale or advertisement of real property. Governed by ARS Section 44-1522, the Act prohibits both active deception and omission. Real estate licensees must also comply with ARS Section 32-2153 and R4-28-1101, which require fairness, honesty, and disclosure in all dealings. Misrepresentation can involve inaccurate advertising, concealment of property defects, exaggeration of property features, or failure to disclose financial obligations. The law is preventive in nature, meaning that proof of actual damages is not required to establish a violation discussion. What is a material fact in real estate under the CFPA? Answer: a material fact is any piece of information that a reasonable person would consider important in deciding whether to buy, sell, or lease a property, such as physical condition, legal status, or financial obligations. Can omission of a fact be considered misrepresentation? Answer: yes. Failing to disclose a known material fact, such as structural damage or a property defect, is treated as concealment under ARS Section 44-1522 and constitutes misrepresentation. How does the CFPA align with ADRE regulations? Answer: both the CFPA and ADRE rules, including ARS Section 32-2153 and R4-28-1101, prohibit false or misleading statements and require honesty and fairness in real estate transactions. Does intent to deceive need to be proven to establish a violation? Answer: no. The CFPA focuses on whether the conduct was deceptive or likely to mislead, not whether the violator intended harm. Closing remarks. The Arizona Consumer Fraud Protection Act serves as a powerful safeguard against misrepresentation in real estate. ensuring that consumers can rely on truthful and complete information when making life-changing financial decisions. For real estate professionals, compliance means more than avoiding penalties. It means upholding the trust that forms the foundation of their profession. By understanding what constitutes misrepresentation and applying principles of transparency, licensees protect both their clients and their own credibility. Honesty is not only a moral choice, it is a legal requirement that preserves the integrity of Arizona's real estate industry.